After I first began writing about politics in late 2005, within the next couple of years, one of the issues on which I focused most, which I talked about most often, was how there was a two-tier justice system in the United States where financial elites and especially political elites are largely immunized from the rule of law. And oftentimes this was taking place in the controversy over many obvious illegal programs that the Bush and Cheney administration have adopted in the name of war on terror, torturing detainees, kidnapping off the streets of Europe and sending them with no due process to Syria or to Egypt to be tortured, spying on American citizens without the warrants required by law. These were all crimes. And when Barack Obama ran in 2008, he was often asked whether he believes that those crimes should be prosecuted, and he always gave the same answer, which is absolutely. Nobody's above the law, and one of the first things I'm going to do when I win is direct my Attorney General to investigate whether crimes were committed there and whether or not there should be prosecutions. And yet the minute he got into office, the media started haranguing him that you don't go and prosecute your political adversaries in the United States. You don't go and prosecute prior administrations. This is only done in banana republics, not in the United States. And my argument always was, well, what if they actually did commit crimes? What if the prior administration actually committed crimes? What if your political adversaries committed crimes? Are they supposed to be exempt from the same rule of law that applies to all other citizens? So if now this were a case where that prohibition, that consensus that has long existed in Washington by the media and politicians, that you don't go and prosecute your political adversaries or the prior administration, if that were being really lifted permanently because people in media and journalism and politics realized it were wrong, I'd be the first to applaud. That's not what's happening here. Another issue that I've been long talking about is how journalism is corrupt when it does nothing more than say the Republicans say this, the Democrats say this, and it's not up for us to decide. We're just going to report what officials say in the U.S. government. We're not going to tell you if it's true or false. And so when the media started after Trump saying, oh, we're going to start calling him a liar all the time, I would also be cheering if it really meant an abandonment of that kind of lazy journalism, that kind of corrupting journalism where you don't investigate what powerful people claim, you just report it and mimic it and then leave it at that. But again, this practice is only for Trump. You will never hear them saying those kind of things about Joe Biden or Democratic Party officials or really anyone else. So this isn't a form of progress or evolution in how we understand things. This is obviously the political persecution and the judicial and legal persecution of Trump and his closest allies, not in the name of equal justice for all, but solely in the name of weaponizing the judicial system against a political movement that they regard with great fear and that they do anything and will do anything to stop, including abusing the legal system. Here from the Wall Street Journal earlier today on the Steve Bannon case, quote, Steve Bannon ordered to report to prison on contempt of Congress conviction. Former Trump advisor was convicted in 2022 and recently lost an appeal. Quote, a federal judge Thursday ordered Steve Bannon to surrender by July 1st to serve a 4-month prison sentence for defying the House committee that investigated the January 6, 2021 Capitol attack and former President Donald Trump's efforts to overturn the 2020 election. In a unanimous decision last month, a 3-judge appellate court panel rejected Bannon's arguments that his conviction wasn't valid because he was following his lawyer's advice when he refused to comply with the House subpoena demanding documents and testimony. The panel said Bannon's advice of counsel defense wasn't valid in contempt of Congress cases and would impede the legislature's investigative authority. Bannon was the first of 2 former Trump White House officials to face prosecution for denying the House panel. A year after Bannon's conviction, former Trump advisor Peter Navarro was found guilty of defying the same committee, the January 6th committee, and was also later sentenced to 4 months in prison. Both cases stemmed from House referrals recommending that the Justice Department bring prosecutions. Now, someone might say, who hasn't looked at these issues for very long, well, if Congress issues a subpoena, you're legally required to obey it. And if you don't obey it, or you go there and you don't give the documents that they ask for and the evidence and testimony that they demand truthfully, you will be held in contempt of Congress, and that is a crime. The problem is that there is a long history of the executive branch refusing to comply with congressional subpoenas on the grounds that they have the power as the executive branch that is supposed to be separate from the legislative power, that they have rights as the executive branch not to turn over information or appear to testify when a co-equal branch, which is Congress, demands their appearance. Steve Bannon and Peter Navarro are by far not the first people to give a middle finger to Congress when they've issued a subpoena, people who are in the executive branch or who were in the executive branch, and yet you'd be hard-pressed to find another case where people explicitly were held in contempt of congressional subpoenas, but who were referred to the Justice Department and or then prosecuted by the Justice Department for it. Here, this is a case where the Biden Justice Department took a referral from a Democratic-run committee, the January 6th committee, that was created under Nancy Pelosi's speakership, a committee where for the first time in the history of our country, the House Speaker rejected the members that the minority, the Republicans, wanted to put on that committee. She said, no, those are not going on this committee. The first time in history that a House Speaker refused to impanel the members of Congress indicated as members of that committee by the House Minority Leader. And instead, as a result, no Republicans agreed to serve on that committee in protest except for two Republicans, Liz Cheney and Adam Kinzinger, who obviously are far more aligned with the Democratic Party when it comes to Trump January 6th. So in effect, it was a fully partisan panel. And so the Democrats in Congress referred these contempt citations to the Biden Justice Department, which in turn decided to prosecute, something almost unprecedented in our history. I just want to give you a few similar cases to understand what a complete deviation this is from how things have typically been done in Washington. Here from CNN, in February of 2008, during the Bush administration, there you see the headline, Attorney General declines to investigate Bush advisors. U.S. Attorney General Michael Mukasey on Friday said he will not ask a federal grand jury to investigate whether two top Bush administration officials should be prosecuted for contempt of Congress. House Speaker Nancy Pelosi Thursday asked Mukasey to look into whether White House Chief of Staff Josh Bolten and former White House counsel Harriet Miers committed contempt of Congress in the investigation of the 2006 firing of several U.S. attorneys. Earlier this month, the House voted to fine Bolten and Miers in contempt of Congress and pursue charges against them. But the White House argues that forcing the aides to testify would violate the Constitution's separation of powers. And that has been the longstanding view in Washington, that if Congress orders a private citizen to appear for a legitimate investigation, and there are all kinds of limits on what Congress is permitted to investigate, and I think it's extremely questionable whether or not they have the authority to investigate private citizens for January 6th, because in general, the only two types of investigations that Congress is permitted to initiate are one, to exercise oversight over the executive branch, and number two, to hold hearings for the purpose of deciding what legislation they want to pass. So if they're, for example, thinking about various legislation related to a certain industry, you call the people in that industry, you call the activists against that industry, and you hear from all the sides, and then you decide what kind of legislation is appropriate. That's one example of when Congress can convene investigative hearings. The other is solely to investigate executive branch officials. It's never to investigate private citizens, and yet that's exactly what the January 6th committee here did. In fact, those precedents saying that Congress can't investigate private citizens for their political views came out of the McCarthy hearings, when the Supreme Court twice in the 1950s told Congress, you're vastly exceeding the scope of your investigative powers by trying to investigate and harass people for their political views. And that's exactly what the January 6th committee did. But even leaving all that partisanship and all that precedent aside, there have been so many other cases where Congress declared a certain executive official to be in contempt of Congress, and it never went to the point where Steve Bannon and Peter Navarro's case have gone. Here from CBS News in June of 2012, another example. The White House says Eric Holder, the Obama Attorney General, won't be prosecuted for contempt. One day after the House voted to hold Attorney General Eric Holder in contempt in contempt of Congress for failing to provide documents relating to the Fast and Furious gun walking program. Many of you may not even remember what that was, but it was a scandal involving the Justice Department and whether they were permitting all kinds of serious weapons to come in through the border, their border with Mexico, through illegal immigration. And the Congress was investigating that. Eric Holder refused to turn over documents. The House held him in contempt. And yet the White House spokesperson for the Obama White House, Jay Carney, said the criminal prosecution of the contempt charges will not move forward. He said the president's assertion of executive privilege over the related documents makes the matter moot. In a letter sent to the House Speaker, John Boehner, Deputy Attorney General James Cole confirmed that justice would not move forward with contempt prosecutions. I'll take you all the way back to 1983, during the first term of the Reagan administration, where you can see just how long-standing this issue is that has not resulted in these kind of prosecutions. From the New York Times, March of 1983, there you see the headline, the Attorney General, that was Ronald Reagan's Attorney General, William French Smith, defends action by the Justice Department in the contempt case. Quote, under sharp questioning today by Democrats on the House Judiciary Committee, Attorney General William French Smith repeatedly maintained that there was no way to prevent conflicts between the executive and legislative branches, like the battle over access to EPA documents. So Congress was trying to get documents to investigate what the Reagan administration was doing with the Environmental Protection Agency, and EPA officials and others refused to hand them over, claiming that that was the executive prerogative to formulate policy and Congress had no right to intrude. And so when William French Smith went before the Congress and they grilled him on why he wasn't prosecuting them and why the Justice Department was, he said, quote, there is a built-in conflict and tensions between the branches, Mr. Smith asserted, adding, quote, as long as we have the system of government, I don't see how we can avoid the kind of problem we've had here. Several committee members expressing dissatisfaction with Mr. Smith's responses demanded a guarantee that the House would not be ignored the next time it cited an official in the executive branch for contempt and sought to have the case prosecuted. The dispute involves the DOJ's action in the contempt case against the head of the Environmental Agency, Anne McGill Burford. These are all causing very ancient memories to return from an old political scandal, but this really was the same conflict between the EPA and Congress. And the EPA director, a woman by the name of Anne Burford, who was highly controversial, she was extremely conservative and put in charge of the EPA, was very pro-industry, anti-environmentalist. And the Congress, run by Democrats for years, the House, wanted to investigate her, and she refused to turn over documents, and the Reagan Justice Department refused to prosecute her for it. Representative Peter W. Rodino, the New Jersey Democrat who is chairman of the committee, told Mr. Smith that by law, the United States attorney had a, quote, mandatory duty to present the contempt case to a grand jury. But he suggested that the department seemed to believe it was free to make its own decisions on whether to prosecute. So just look at how many cases involving Republican administrations and Democratic administrations where members of the executive branch or people close to the president refused to turn over information demanded by subpoena by congressional committees who were trying to investigate the executive branch. And typically, because of this notion that the two branches are co-equal, one is not in charge of the other, one can't order the other one around. Nancy Pelosi can't pick up the phone and order Donald Trump to appear before Congress or order his White House chief of staff to appear before Congress, because that would make the Congress supreme and not a co-equal branch. And that's why the two parties, the two agencies, the two branches of government are constantly fighting with one another over when they have to turn over documents. And it's an inherent and natural part of our system that has often been resolved politically, but almost never with prosecutions, even when, as in the case of Eric Holder and other instances, the Congress declared that official in contempt of Congress and referred the contempt charges to the Justice Department. In all these cases, the Justice Department refused to prosecute until, as always, that consensus, that ethos, that rule in Washington for how Washington runs was completely abandoned solely for Donald Trump and his aides. I mean, there's just no denying that all of these long-standing precedents in Washington, for better or for worse, and I'm against a lot of them, I'd be the first one applauding if they were really undone. That's not what's happening here. This is a one-time only suspension of these long-standing rules, not an abandonment of them in the name of criminalizing the Trump movement and doing everything to sabotage Donald Trump's attempt to return to office. Now, as I suggested at the start, this ethos in Washington was a major part of my journalism for the first 10 years. It was a topic on which I focused incessantly. And that was because I had started writing about the war on terror, and I began to see that a lot of what was being done by the Bush and Cheney administration and the neocons who ran the relevant agencies was not just misguided or dangerous or destructive, but was illegal, criminal. that definitely included the way the Bush administration was spying on American citizens without the warrants required by law. Something that Congress went and retroactively legalized in 2008 that became the FISA law that now gets renewed all the time, and that just got recently renewed to allow spying on American citizens with no warrants. But at the time, it was plainly illegal and criminal. Same is true for torturing detainees, which had always been a crime in the United States, kidnapping with no due process, and others similar ones as well. And so every time I was arguing that these were crimes and that they should be prosecuted, what I always heard from longtime journalists in the media and from the consensus in Washington was that, well, it doesn't really matter if those acts are illegal or not, because here in Washington, we don't prosecute top-level political officials for the acts they've undertaken as part of their executive branch duties. That only happens in banana republics. That's called criminalizing policy differences, or criminalizing legal disputes between the two branches, and you just don't do that. Otherwise, you're going to have a never-ending cycle of retribution where one party is putting the other in prison the minute it gets hold of the levers of the Justice Department. One of the first debates I ever had with a classic member of the corporate media was when NBC News' Chuck Todd went on the air and basically scoffed at the idea, and this is in 2009, the first year of the Obama administration, that there should be any investigations at all, criminal investigations of Bush officials or what Bush officials did in the past or CIA officials did or the NSA did. Because it's just a distraction, he said. It doesn't really matter. It's not the stuff that Obama should be doing. He should be caring about appearing as a centrist, those sorts of things. And that in Washington, we just simply don't prosecute prior administrations or our political enemies. And I can't tell you how many columns like that were written, how many TV pundits went on cable news and said that. It was the overwhelming consensus. I can't think of anyone in corporate media who believed that President Obama should criminally investigate or prosecute prior acts of the Bush administration. And in fact, so intense was the media pressure on Obama that despite promising repeatedly in the 2008 campaign that he would give it to his attorney general with the instructions to look into it, to investigate it, and to prosecute if there was reasonable grounds for believing crimes were committed, saying, I'm not going to be involved. This is a legal question. Nobody's above the law. I'll ask my attorney general to look at it. 2 months into office, Obama announced that he was not going to allow any prosecutions of anyone in the prior administration, including in the CIA, for any of these crimes, pronouncing it's more important that we look forward than backward, which never made any sense on its own terms because all criminal prosecutions, by definition, require looking backward. By definition, they're acts that were undertaken in the past. And so if, when it comes to the prior administration, we're going to adopt the view that we don't look backward, we only look forward for the good of the country or whatever, then it is a complete immunity or exemption for politicians from being prosecuted by the law in the same way that ordinary American citizens are prosecuted. And I was indignant about this. I wrote article after article. I wrote, as I said, a 2011 book arguing against this mindset. And in 2009, I had a big enough platform that I really couldn't be ignored any longer by people in the corporate media. And so I wrote an article about Chuck Todd's comments and heavily criticized them. And he said, hey, I wish you had talked to me before. And I said, well, I don't think I have the obligation. I'm just criticizing your public remarks, but I'd love to engage you on this. And why don't you come on and we'll do a podcast and I can ask you questions and you can ask me and we'll debate this issue. And here you see Huffington Post in August of 2009 reporting on that debate. Chuck Todd and Glenn Greenwald debate torture and the media. So I'm just going to give you one passage from this discussion that I had with him to illustrate to you how adamant these people were that we cannot have prosecutions of our political adversaries or our past administrations. So I said to him, quote, let me ask you about that then. If a president can find, as a president always will be able to find, some low-level functionary in the Justice Department, a John Yoo, to write a memo authorizing whatever it is the president wants to do and to say that it's legal, then you think the president ought to be immune from prosecution whenever he breaks the law, as long as he has a permission slip from the Justice Department. I mean, that's the argument that's being made. Don't you think that's extremely dangerous? He then replied, that could be dangerous, but let me tell you this. Is it healthy for our reputation around the world? And this, I think, is that we have to do what other countries do more often than not, so-called democracies that struggle with their democracy, and sit there and always put the previous administration on trial. You don't think that we just will start having retributions on that going forward? Look, I am in no way excusing torture. I'm not excusing torture, and I bristle at the attack when it comes on this specific issue. But I think the political reality in this, and I understand where you're coming from, you're just saying just because something's politically tough doesn't mean we shouldn't do it. I don't disagree with you from 30,000 feet. That is an idealistic view of this thing. Then you have the realistic view of how this town works. That is what he was saying. He said, oh, it's very idealistic to think that prior administrations or political officials in Washington are going to be held accountable under the criminal law the same way ordinary citizens are. He said, I don't disagree with you. Looking at things from 30,000 feet, this very kind of idealistic academic view that you have, this idealistic view that you have that people in Washington should be held accountable when they violate the criminal law like everyone else does. And then he went on to say, then you have the realistic view of how this town works, lecturing me. You're not a elite in Washington. You don't understand Washington. You don't live here. You're not. You don't work here. You don't know these government officials. I'm going to tell you what the realistic view of how this town really works, not the idealistic view that you think that people can be prosecuted from the prior administration if they break the law. This is really how the town works. And he said, quote, and what would happen, and is it good for our reputation around the world if we're essentially putting on trial? Is it good for our reputation around the world if we're essentially putting on trial the previous administration? We would look at another country doing that and say, geez, boy, this is, essentially like what tyrannies do or what banana republics do. And the reason I was so interested in having this conversation with Chuck Todd is not because he was some aberrational voice in the US media. Just look at this ethos here that you just, in Washington, the hardcore reality, if you know how Washington works, is you do not go around prosecuting your political opponents, people in the other party, people from the prior administration. This is what they had been saying for decades. For decades. It's how they excused the pardon of Richard Nixon by Gerald Ford, even though the evidence was overwhelming that you could have convicted Richard Nixon of crimes the way you did with many of his top aides, all of whom got pardoned. During the Reagan administration, there was an Iran-Contra scandal that involved highly likely criminality on the part of Reagan officials who wanted to fund the war in Nicaragua, fund the Contras in a civil war, even though Congress had passed a law saying any funding of the Contras in Nicaragua is illegal and hereby banned. The executive branch went and ignored that law, but they couldn't get funds from Congress, so what they did was they sold highly sophisticated missiles and other weapons to Iran, got the cash at the White House in secret accounts, and then sent that money secretly to fund the Contras, even though Congress had said you can't. And a lot of the top officials in the Reagan administration were at risk of being prosecuted, including George Bush, the then vice president. And the minute George Bush got elected, the first thing he did was issue a pardon of Caspar Weinberger and of every other Reagan administration official. And most people in the media applauded that and said, yeah, we can't be distracted by these kind of prosecutions. We can't be prosecuting people in Washington. It's too much of a distraction. It makes us seem like a banana republic. This has been the argument for so long. And if I really believed that this was finally being lifted, and the idea was, look, we're going to prosecute people no matter how powerful they are in Washington, anytime they actually break the law, I would be the happiest person. I'd be the first one to stand up and cheer. But it's so obvious that's not what's happening. There's no remorse or regret about how this was done previously. The minute Trump is out of the scene, they're going to return right again to this rule, this ethos, this hardcore reality, independent of the idealistic view, that in this town you can't really go around prosecuting political adversaries and prior administrations because it's going to make us look like a banana republic. It's a one-time exception only, as so many things are, for abusing and weaponizing the justice system against one person and one person only, and that is Donald Trump. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern, exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.